It is the choice of principles that's the tough part. And that's a choice that is made, among other things, simply on the basis of fact. We have to know how it would work out one way, how it would work out another way, and make a choice based on those predictions and on what experience teaches us from the past.
Brown v. Board of Education, as many of you will remember, was the case in 1954 where the Supreme Court ruled that discrimination in public education by separating the races violated the Equal Protection Clause. And in Brown, what the court did was to abandon a belief that the idea separate but equal treatment of the races was constitutional. It had announced that proposition some 50 years earlier in a case called Plessy. Plessy involved separating the white race from the black race in railroad cars. And the court in Plessy said that was all right. It didn't violate equal protection.
This case had to do with a law in Louisiana that required whites and blacks to ride in separate railway cars. Right? That was the law of the land in Louisiana. The plaintiff was a man named Homer Plessy, who was denied entry into the white railway car because he was 1/8 black by ancestry. Right? He was 1/8 black, but he was still considered black under the laws defining blackness in Louisiana. So he sues the railway, asserting that his constitutional right to equal protection under the laws was violated. Right? So the question for the Supreme Court is, well, what exactly does equality mean here? Right? It's true that blacks and whites are separated into these different railway cars, but why is that necessarily unequal? The Supreme Court thinks about this, and in an 8-1 decision, the court at that time, 1896, right, the court says putting blacks and whites in separate railway cars did not violate constitutional equality, right, as long as the facilities provided to both races are the same. Right? So the court, right, this is the famous separate but equal doctrine, right? The court rejects the argument that this sort of legalized segregation stamps the colored race with the badge of inferiority, which is what Plessy had argued. And the court says, if this be so, right, if there's a perception of a badge of inferiority, it is not by reason of anything found in the law, but solely because the colored race chooses to put that construction upon it. That's what the court says.
It's natural. I've done it myself to go around saying, you know, Plessy was wrong the day it was decided. But that, in fact, is unrealistic, and I think it's unfair. The issue in Plessy was really just like the issue in Brown. The fact that one was on railroad cars and one was about school buildings and so on doesn't make any difference. And the issue that sort of never got stated exactly because nobody really had it expressly in mind was, what are the facts that we ought to consider in deciding whether there is equality or not? What Plessy said was, we're going to consider the kind of objective, physical, measurable facts. Are the railroad cars really the same? Do the same upholstery on the seats, etc., things like that? They took kind of a formalistic, physical view of it. The big difference was that what the Brown case saw as the facts were not simply, you know, the measurable things like nice buildings and clean textbooks. They looked beyond the measurable facts to what the facts meant. And they knew that those facts meant to anybody, whether white or black, that the people who made the law and enforced it were enforcing separation because they believed that the black group was not as good as the white group. And that's why they said the very fact of mandated separation was inherent inequality. Was the court in Plessy dishonest or stupid or demonstrably wrong when it didn't look to meaning? And this is where I think one has to have some political perspective. Because what we can see changes over time depending on our experience. The court that decided Plessy and Ferguson in 1890 consisted of judges who remembered slavery. And if you remembered slavery, the idea that there was a constitutional guarantee that the formerly enslaved population and their children and grandchildren were entitled to exactly equal facilities on a railroad with the formerly dominant white population. That looked like real progress. But the court in Brown v. Board of Education, as you said, it had 60 years since Plessy, and it had 90 years since the end of slavery. And it no longer had the background of slavery to look at physically equal facilities and say, hey, this is great, we're making real progress. What in fact it had was a concept of slavery as something that happened long before we were here. And it was obvious to them that the only reason for continuing the segregation was to enforce a judgment of inequality.
You'll remember that President Truman integrated the Army during World War II. And many of you who were baseball fans will remember that Jackie Robinson in 1947 broke the color line. And that by 1954, for those of us who were old enough to be watching baseball, we could see a number of highly regarded black players on our TV in our homes. They were very much a part of our life. And that was a judicial perception that was present in 1954 that was not present back in 1896 when Plessy got decided. And I think, and I will submit to you, it is the way in which the Constitution keeps up with the times and changes over time.
In fact, the court explicitly says, in approaching this problem, we cannot turn the clock back to 1868 when the 14th Amendment was adopted, or even to 1896 when Plessy v. Ferguson was written. The court says, we must consider public education in the light of its full development and its present place in American life throughout the nation. And considering the centrality of education in our society, right, and the actual social meanings of racial segregation, the court concludes separate educational facilities are inherently unequal. In other words, the very act of classifying school children by race is an act of inequality.
What we learn from Brown is that the facts can include the meaning of facts as people experience them, as long as we have the eyes to see that. And our capacity to see that changes over time, and it changed over the time between Plessy and Brown.